This is part 3 of my podcast episode with Phillip Coburn, and what we'll be discussing in this one is what the landscape looks like further on down the line of possession claims. So with the courts already delayed, how is that going to look when the Renters' Rights Bill comes in? What new grounds are in the Renters' Rights Bill as well to get possession of your property back? We'll hear some real life stories from Phillip as well, so you can listen to those and avoid those same mistakes. So if you like what you've heard in the previous 2, you'll definitely love what you're hearing in this one. And if you like what you hear, then make sure that you subscribe to the Investors Corner podcast. So let's talk about solicitors, letting agents, landlords. Like I mentioned earlier in the podcast, you'll get some landlords that think they know everything and want to do everything themselves. You'll get some letting agents that deal with the responsibilities and liaise with the solicitor directly to help their landlord, or you'll get landlords that go directly to solicitors. But where do you think it's easier for a landlord just to go directly to a solicitor? And the reason why I ask that is because I've been in situations before where we've got that good relationship with the landlord.
Yep.
We're trying to help the landlord by advising them what to do, but we're not legally trained.
Yep.
We could say something that is totally different to what you would say. And what I tend to do now is that if landlords need advice, I point them directly to the solicitor. And as an agent, I don't get involved with that side of things because I don't want to give the wrong information. But other agents are different. So do you think that, letting agents play a role if something goes wrong? Or do you think that lettings agents could potentially make things worse rather than a landlord going to you directly?
Yeah, I mean, it can be any of those things, to be honest. I mean, It depends on what's happening. So firstly, you might have a letting agent who maybe they're trying to grow their business, so that the service they're offering to landlords says if something goes wrong, we will serve an initial notice, and they're contractually bound to do that. They're not getting paid for it as an extra, but they've said they're going to do it, and them doing it saves the landlord have to pay a solicitor to do it. So you could have that situation, and lots of. There's a bit of a mix, really. Lots of agents won't touch it, as you've suggested, because why would I? There's a risk. If I get it wrong, I'm not getting paid for it. And all that's going to happen is I'm going to get a complaint if it goes wrong.
Yeah.
But you have agents who make specific charges. So they don't offer it as part of the normal service, but they will make an additional charge to the landlord for doing it. So it's a money-making exercise. So again, there's nothing wrong with that. That's fine. But there can be mistakes. So there's no right answer as to which way is best. As long as you get to the same conclusion, really.
Yeah.
So I will work and have worked in any of those situations. So I would have clients who I've got portfolios, they've never used an agent ever, and they're fine with that. And I sort the paperwork out. Yeah. I have clients who never even seen the properties probably, and agents have managed everything, and then the agent won't do anything with the notices as you've suggested, or some are very insistent that no, we'll do the notice, and then I come in afterwards. Or I can have cases where landlords have issued proceedings and there's a hearing listed, and I'll just step in at that point and deal with the hearing. So really step in at any point, but the main thing is working together. It doesn't matter to me personally, and probably shouldn't to a landlord, if the agent's done some paperwork or the solicitor has, or the landlord. It just matters that it's all correct. And if it's not all correct, everyone's still got to kind of work together to get it correct, because I might look at something and have 10 queries. It doesn't mean it's wrong. You might be able to answer all 10 of them, and I say, okay, that's great. We can get on with it. Or you might say to me, no, I can't answer that one, and there's a problem. And then you might want to have that conversation with the landlord rather than me, and explain to them what's happened. But So it really just depends on the individual, depends on your business makeup of how you're structured and how you want to work. But landlords make mistakes, agents make mistakes, solicitors make mistakes. Certainly, you know, there's plenty of times that I've dealt with cases where someone before me has made a mistake, and that's fine. It's done, but you get on with it. And, somebody else is taking it over. Or you can have an opposing party who will tell me I'm wrong, and if I'm wrong, then I will happily say, yeah, you're right, actually, it's wrong, or vice versa. But there should be that. It's not like a point scoring exercise. You should just be able to, again, it's figuring out the problem and coming to the same conclusion as how to get my property back.
It's finding the solution, isn't it? And that's what ultimately you want to do. I think with agencies, I think a lot of them do the Section 21 notice themselves, because I mean the Section 21 notice is a pretty basic notice. It'll be hard to get it wrong. It's just really, tenant's name, the address, the date, serve the accompany notes with it, and just make sure that information's all right. But the Section 8 notices, there's a bit more detail on Section 8 notices, right? And it's easier to get wrong. You've
got to... firstly, on the Section 21 point, they're very straightforward to fill in. Quite a common problem I tend to get if somebody else has done it is that you probably know there's 3 deposit schemes, and each deposit scheme will have a different set of rules. So one may say you need to give this specific PDF leaflet to the tenant. Another one might say you need to give our terms and conditions to the tenant. And if you can't find any evidence that little extra bit's ever been done, it might have been done, and the agent may say, I've done it, but it leaves me in a position where I've got to say to the landlord, we've got to tick a box in the court proceedings which says the tenant was given prescribed information about the deposit and on which date. If the tenant just does a bare denial and says, I never had that, the burden of proof is on you, landlord, to show that they did. So where can I get that evidence from? And the answer might be, we don't have the evidence. It's and then I'm having to say to the letting agent, okay, are you going to come to trial and stand in the witness box and give evidence that you did that? And they might say, yeah, and that's great, but lots of the times it's, well, I can't quite fit it into my busy schedule. I'm getting paid for it, and you can't, pay a witness to give evidence. So,
No.
But the Section 8 one, so usually it's because it hasn't got the right information in it. So it still has the same points of name of landlord, name of tenant. It's signed, it's got an address. But on the form, on the notice, it asks you on what grounds or reasons you're seeking possession on. And then you need to set out the statutory grounds. So you can copy them from Schedule 2 of the Housing Act 1988. They're right there. So it will be ground 8 if it's rent arrears, for example, 10 and 11. But then you've got to say why you're seeking possession. And that's so between those 2 paragraphs usually is where the errors come. So someone might not fill in the statutory grounds. I might just say because of rent arrears. And if you go before a judge, who, as you were saying before, judges might look for any small thing. If you haven't set out the statutory grounds, the judge may say, well, how can I make an order giving possession under a statutory ground if you haven't relied on the statutory ground? So you haven't said ground 8. You've just said because there's rent arrears. Well, how do I know that's ground 8? Could be ground 10, which is a discretionary ground of some arrears. Could be ground 11, which is persistently late paying the rent. So you're not having your order, sorry. So it's easy to get those bits wrong. But even the rent bit is relatively straightforward. It's usually other grounds for possession. So antisocial behaviour can be a quite a big one. So say you can't do Section 21, you're not selling your house, you're not moving back in, there's no rent arrears, but the tenant, all you ever get is complaints from neighbours about parties, misbehaviour, smells of cannabis, any number of things. In an ideal world, what I would do on the notice is I would say on date X at time Y, a complaint was received which said you were playing music at 10 o'clock at night with the windows open and it was really loud, or someone could smell cannabis, or you threw something over the fence. But sometimes people just put one line of all the tenants being a bit naughty.
Yeah.
It doesn't really help. So they're the things that people can get wrong, of not putting enough information. The way that court look at it is that the notice needs to be sufficiently clear for a tenant to understand it. And it's a bit unfair an unfair view, because judges will take an assumption or make an assumption that if you don't show how rent arrears are calculated, or you don't break down every single point, then tenants may not understand what that means. Well, landlords may not understand what that means, but it's by understand, the point is it needs to be sufficiently clear. That's what if you just say because you owe rent or because you've misbehaved, that's not really helping. You need to put the detail in, and that's where they kind of can go wrong. Not just on the notice bit, but when people issue proceedings, you need to repeat that really and set out, what's gone wrong and why and how. You need to show you're working out, as if it was an equation, basically.
Yeah. Question for you. Prescribed information.
Yes.
So I've recently been advised by 3 different people now.
Yeah.
And they've all come, 2 of them have had the same sort of answer, and one had a slightly different answer. So whilst you're here, I'm going to ask you, prescribed information, does that need to be served to a tenant? Or does a signed copy of that by the landlord need to be served to the tenant before having the fully signed copy go to a tenant? And the reason why I ask this is because there's an insurance claim.
Yeah.
And the insurers being insurers, we had a fully signed tenancy agreement. The prescribed information was contained within the tenancy agreement.
Yeah.
That tenancy agreement goes to the tenant to sign first.
Yeah.
Then it goes to the landlord to sign.
Yeah.
And then once they've both signed, that tenancy agreement is fully executed between both parties, and they receive a fully signed copy of the tenancy agreement and the fully signed prescribed information. Now, the insurers came back to me to say that the prescribed information wasn't served to the tenant signed by the landlord at the very start of the tenancy. So they weren't allowing a claim to happen.
Okay.
But what I went back to them and said is that the tenants received a fully signed copy within 30 days of the deposit being received before the start of the tenancy.
Yeah.
And all right, it wasn't signed when they received the tenancy agreement to sign, but they've still received a fully signed copy. So what's the point of me now reserving prescribed information to a tenant that is only served by a landlord when they've got a fully signed copy already?
Yeah. So I think I understand the point. So again, you probably know this, but so the Housing Act 2004 says, as well as protecting a deposit within a specified time, currently 30 days, you have to give prescribed information within 30 days. And the prescribed info is made up of a few different bits. So one of those is information which is set out in a really long worded piece of legislation.
Yeah.
And in that, there's a big long list of everything that needs doing to comply. And that's usually why you might use a template off the website from the company. And some agents or landlords will incorporate that within the tenancy. But one of those points in that big long list says you've got to provide a signed copy of the prescribed info to the tenant and give them the opportunity of signing it. So for the start of your query, if you send an unsigned tenancy to a tenant which contains the prescribed information, I don't think that deals with the requirement of providing a signed copy at that point. But the tenant then signs it and sends it back. If you then send them back a fully signed copy, which has got your signature or the landlord's, whichever, and it's the same agreement which has the same prescribed info, you must have complied with the rule that you've provided a signed copy, because it is signed. So the reason I say that is, one, it just tells you to provide a signed copy, which you have. But I know there's 2 consequences of not dealing with deposits correctly. One's a money claim to say you can have the tenant can have the deposit return plus up to 3 times the amount of the deposit.
Yeah.
But the other is you can't do a valid Section 21 notice. But if you look at the Section 21 point, what is acceptable is that if you fail to give prescribed information within 30 days or ever, that might have a problem about the claim. But in terms of Section 21, as long as you do that before you serve a Section 21 notice, it's okay. So if you're allowed, in other words, you're allowed to give the prescribed info at the later date. But in your situation, if it was in 30 days and the tenants had it, I don't really see what the issue is.
Well, that was my point.
Yeah.
So that was my point to the insurers. They haven't yet responded to my comments, but we'll see.
So this is a claim that a tenant's made, is it, for not doing it?
The Section 21 notice was served. The tenant failed to vacate, and she's not going to vacate.
Yeah.
So now we've had to issue legal proceedings to evict her. But the landlord has rent and legal insurance, which is what we get a lot of our clients to take out now. So you've got the legal expense cover, you've got the rental arrears cover as well. But the insurance the insurers in this particular case said, because of that prescribed information element, that they weren't going to take the case on. To which I responded to them and said, well, this is exactly what happened. This is the evidence that it happened. These are the dates and times on when the tenant received it, when it was exchanged, when the landlord signed it, etc., etc. So, like I said, they haven't yet responded to me. So I'm sure, hopefully, they'll change their tune.
Yeah, well, I mean, it's one of those. I don't like giving. I'll happily give generic legal advice. There's no problem with that, but it's for a specific case. I'd need to see it. Which I'm happy doing, by the way. But if, like, generally speaking, if you've only got the tenancy and the tenancy has the prescribed info, and after the landlord signed it or the agent signed it, it's gone back to the tenant, like, here's the fully signed copy, that deals with the point. If the tenant signed it, sent it to you or landlord, you sign it, but then never send back the signed copy, that would be a problem, I would say. So it depends on whether it's gone back at some point, or alternatively, there's another prescribed information template. Depends how different people work differently. Some do it within the tenancy, some do the separate template. And then in any event, it would have to have the right information in it. So it would still need to have all of the boxes ticked that it is the right prescribed info, it complies with the scheme's rules. So if it was the DPS, for example, they have terms and conditions, so you would have had to provide the terms and conditions with it. Or if it's the TDS, it's a what is the tenancy deposit scheme leaflet.
And a lot of landlords fail to do that, by the way, when they look after the deposits themselves and register it either with TDS or DPS or My Deposits. They sometimes forget to send those terms and conditions along with everything. I know various landlords, when I used to be in London, that got caught out where they thought they could do everything, and the tenants have claimed 3 times the amount, because nowadays you get insurance companies ringing people up saying,
are you, or on Facebook,
are you a tenant, have you been a tenant, were you given the prescribed information, were you given X, Y and Z, and then they start issuing claims on behalf of them. It's
the same scenario. 20 years ago, for example, you stopped in the street saying, have you had an accident in the last couple of years? Now it's, have you paid a tenancy deposit in the last 6 years? Excuse me. And but I mean, on that, if they've done it wrong, I said the Section 21 point, I think, can be remedied anyway. But if it's a money claim, it's not only the fixed term. Sometimes it can be more than 3 times. So, a standard claim might look like the deposit's never been protected ever, or the prescribed info's never been given. So it wasn't given within 30 days. So there's a breach of the Housing Act 2004, which says a claim up to 3 times. But then when the fixed term ends, if within the tenancy it's silent as to what happens after the fixed term, it becomes a statutory periodic tenancy. And there's case law which says that's a new tenancy. Because it's a new tenancy and the deposit's still not protected, that's a second tenancy where there's an up to 3 times.
So it could be 6.
So be 6 times.
6 times. Wow.
And then, depending on how claimant solicitors word their claims, they can say, well, you didn't protect it, so that's one breach, but you didn't give prescribed information, so that's another breach. So there's 3 times for not protecting it and 3 times for not giving prescribed info. I don't agree with that way of looking at it, but there's case law either way.
Yeah.
And it's very much up to I think lots of judges take the opinion, well, how can you give prescribed information if you didn't protect the deposit? So it's all the same thing.
Yeah.
But yeah, it can be an expensive mistake. But you know, on your point about the Section 21, the rules do say anyway, you've given the prescribed info, or if not, you've given it to substantially the same effect. So even if your insurer is right, there's still a backup argument of, well, it's all there.
Yeah.
It just didn't have the signature on. It's still substantially the same effect.
Yeah.
But there are cases where things have, tenants have succeeded because it wasn't signed. But it is signed. This is the point. It is signed.
Yeah.
It's just whether it's gone back. And I don't know what the normal business model is, that when a landlord or agent signs it, do you say to the tenant, here's the fully signed version of your tenancy? So if that bit's been done, I don't see it.
Yeah, exactly. I mean, look, everything's sort of teched out now in tenancy progression within agents, where tenants sign to say that they've received the documents. Tenants are given a executed copy of the tenancy agreement as soon as when it's fully signed, and then a welcome letter will be sent with all the attachments again. So they probably get all of the documentation at 3 points before their tenancy's even started. They'll get it again on renewal. So that's the tech at the moment, where it's just creating that sort of slickness and automation that tenants will get it. It's just the landlords that don't have that are the landlords that can get caught out by one different,
it's very easy to get
it's in one document or one mistake made. And, there's a lot of landlords out there at the moment that use Open Rent. And it's sort of a self-service platform for landlords. Now, one thing that Open Rent don't do is they don't serve the safety documentation to tenants. So they'll serve the tenancy agreement. They'll sort the deposit out. But the safety document stuff, that does not go to tenancy. The landlord has to do that. And I've spoken to landlords that have been caught out by that. So it's okay. It's great spending, less money in getting a let agreed, but if you're not up to the compliance or the regulations of renting a property out, at some point it will hurt.
You'll be very lucky if you go through your career as a landlord. If you don't have a problem, you have a problematic tenant, there are no rent arrears, and by chance you get away with not having. It should be clear. I'm not suggesting, and no one is, that landlords are choosing to not do these things. I don't think not at all. You still have people who aren't aware of the requirements about deposits, or they don't know about licensing, and licensing changes all the time. I mean, where I live, there's been a licensing scheme in for a number of years, but this September it's expanding. So in September, you might have a landlord who's always had a license for one property and they've got another one somewhere else, and they haven't got a clue that that now needs a license, because I don't think this has been publicised. It's on the council website. So that's going to happen, and that's happened in a lot of different areas. So it's easy to fall foul of all these rules and end up in a pickle. Absolutely.
So Philip, give me your best story, your best legal story, the most outrageous case that you've had, if you can, honestly.
I can. I've only got two. I was saying there's probably too many to mention. I mean, really different things, really, because I've done work in the private rented sector for a long time, but I've also worked in the social housing sector, and you can face very different problems. So, but certainly, I remember probably when I was a lot younger, maybe a bit more naive as a lawyer. I acted for a landlord, and a tenant complained of disrepair at the property or something, and I'd agreed to go to the property with the landlord, to take notes effectively, because I thought it was a good idea. And I got to the property and I couldn't access the front door. There was a kind of a shop downstairs, and I think the flat was upstairs above the shop or something like that. And the tenant had shouted out the top window, like it's flooded or something. Can't come in, it's flooded. So I had to go around the back of a 3-story building, up a fire escape, and climb through a top floor window to get in, and then go all the way back down inside to find, actually, there's water about 3 foot high on the ground floor. So there must obviously be an issue.
Yeah.
So anyway, the landlord comes along a few minutes later, and they start arguing and fighting. And the tenant goes off and locks the door and comes out with a bat. And I'm thinking, what have I done here? So I called the police. And then I went back out the window and got in my car and drove off. And then I had to sack the client, basically, to say, I'm not, don't put me in that position. And then, but other things, like sometimes I will, nowadays, because I'm a bit more, I was going to say sensible, I've always been sensible, but if I need to serve notices on people, usually I'll post them as first class post, and that's fine. Some things need personal service occasionally. And, I remember going to do this at an empty shop, or my instructions were it was an empty shop, and I was seeking forfeiture of a lease, because I do commercial stuff as well. And the shop was closed down, but as soon as I got there, I realised the front door was open and there was a guy working in the property. I thought, oh God. So I kind of popped my head round and put the letter on the doormat, and then he started chasing me down the street with a tin of paint and threw paint over my back. And but that was, again, nowadays, I make sure if anyone's asking me to serve things personally, I say no, and you can pay a small fee for a process server to do these things. But, in terms of cases, more so in the social housing sector, you kind of come up against a lot more of the weird and wonderful stuff. And largely it's because the social housing sector tends to look after tenants who are more vulnerable than those in the private rented sector. So maybe through no fault of the tenant's own doing, they've got some mental health problems. But so I wouldn't talk about those ones, but sometimes there are just people who aren't very nice, and I've had situations where someone's been murdered in properties, like cannabis farms. It's quite a common one, a cannabis farm in a property, and any number of things that you'd probably see, on Shameless, for example, that's something that you just think, this is a bit much. This, so probably. Probably seeing a lot of things, to be honest, and get a lot of abuse, and because it's not, obviously I'm not the person who goes and evicts somebody, but I am at the cold face, and I'm ultimately, my name's on various things, and people will send you emails, kind of abusive, and things like this, and you kind of can be a bit cautious sometimes of thinking, do I need to have a look over my shoulder or something, and these types of things. But so I try and I say that as I'm on a podcast. I'm just try and keep my head down a bit more nowadays. So so pretty much you name it, I've probably
Well, over 30 years, you've probably seen it all, and had those weird and wonderful experiences. So, Philip, what do you reckon the legal landscape will look like for landlords in 2025, 2026 then? Because, looking at the Renters' Rights Bill, if we go by the timelines that we're seeing and that we're hearing, more than likely it's going to come into effect or pass towards the end of this year, with implementation either at the end of this year or early beginning of next year. So what do you reckon it's going to look like?
Well, the obvious thing which we've discussed is Section 21 will be gone, but although that's the headline end of no fault evictions, if you look at the reason for it is because assured short-hold tenancies aren't going to exist anymore. So, an assured short-hold tenancy in AST is a type of assured tenancy. So instead of ASTs, everyone will have an assured periodic tenancy. So even if you're signing tenants up today or they've been there 10 years or whatever it may be, as soon as the legislation comes in and is implemented, you don't necessarily need to have a new agreement for older ones. The law will just say they're now an assured periodic tenant, but there will be new template agreements, and agents may be signed up to get templates of things. The government will publish one that they recognise as a decent template to use. I think rent will increase and has been increasing. I think market rent will go up. Certainly, if there's less available properties, there's more homeless people. Social housing is not being built. There's going to be a demand for it.
Yeah.
So that will happen. I think I mentioned there, but I think there will be less properties to rent because, a lot of people I speak to generally, their clients are selling up for having these fears, or they just can't be bothered with the new changes. To be honest, it's maybe they're too long in the tooth for all these new things nowadays. So it will be the no-fault point gone. I think payment of rent will increase the amount of rent, and more homeless people, because someone's got to pay the rent. If they can't pay it, unfortunately, the landlords will either have to stomach that or seek possession. And so, having said all of that, I've said this before, but there've been changes in the law over time anyway, and smart landlords, agents, and lawyers will just adapt to the change. And I don't think it's something to worry about. I think it's just a case of embracing what the changes are. I'd be more kind of worried about and it will be there. There'll be legislation to look at. Be more worried about knowing what the act is once it's in place. Yeah, but you're not going to see that until it's there. So, it'd just be landlords need to be aware of it.
Yeah,
be aware of it.
I think that's the big thing for me, is that what we're seeing at the moment is, all right, it's more than likely what's going to come into effect, but without it sort of set in stone that this is exactly what it's going to be. The guidance is all being written out, everything's ready to go. It's still that uncertainty element of, is it going to happen? Is it not going to happen? Or are the specific clauses going to happen? Are they going to be reworded? So it's hard to implement any changes at the moment until you know the exact wording of everything. And then once the guidance has been set, then like you said, you've got to embrace it. You've got to get on with it. You've got to deal with it, and you've got to adapt to it.
Definitely. And ultimately, whether you look at this law or the old law, whatever it is, people will want to rent properties. Yeah, people will want to own properties and have investments, and there'll be people like you and I who kind of look after landlords' interests. So there's not, you could say, well, what's changing? It's people are still renting properties, and landlords can still ask for their properties back if something goes wrong, or if there's another. Which is my
sort of, don't panic type style, because like you said, you're still going to have people that want to rent. Investing in property is still one of the number one things to do from a security and investment point of view. It's bricks and mortar at the end of the day. It's something physical. You can see it, you can touch it. So I think, look, we might see a little dip in rental properties coming to the market, but I don't think there's going to be a massive sort of dip in that, if I'm honest with you, because as long as they've got the power team, they've got the right people advising them on what they need to do, and they've got that support there, there's no reason to panic whatsoever, because you can still get your property back. And that's the main thing, right, is that you can still get your property back. It's not, once you've got a tenant in there, you can't get them out. No, you just got to go through a few different avenues to get the property back.
It's not it's not old-fashioned legislation like the Rent Act, 77. It's not secure tenancies where someone's on £1 a week and you have to get them out. It's it's not that at all, really.
No,
so there's still reasons to ask.
Exactly.
Ask for it back.
One piece of advice every landlord should know then. Can't hit me with it, Philip.
I'd probably, and we touched on it, but just be very cautious about doing things yourself.
Yeah.
And don't, there are people out there who can help, but some people can give the wrong advice. So Facebook's not a great place to go off seeking advice, unless, if the advice is from lawyers, for example, is different.
Yeah.
So it's try not to do everything yourself and have a good team, whether you use them all the time or not. You have someone you can call on.
Yeah.
Ideally, have an agent. It takes the headache away of dealing with the day-to-day things with a tenant, or have a lawyer. Not all lawyers, make you put a card in a card machine every time you want a piece of advice.
Yeah.
It's, certainly I've never worked that way. I've always been happy to have a chat with people.
Yeah.
And maybe they come back 6 months.
Yeah, exactly.
2 years, never, I don't know. But at least they know you and may recommend you to somebody else. And it'll be the same for agents as well. They might not give you business now.
Yeah.
But, they may do later on.
No, good advice. I mean, it's one thing that I always say is that try not to do everything by yourself, because it's just why would you want to, especially with all of these changes happening. So we'll end on a couple of questions I've got for you,
okay,
Philip, and they're questions that do come up quite regularly, to be honest. So one of the questions is that I've got a tenant in arrears and they've stopped responding.
Yep.
What do you do first?
Well, there's the legal remedy is to seek possession. Right? It doesn't mean you have to do that. But so if you're going to go down the legal remedy route, well, you would calculate the rent arrears, and then you'd decide what grounds for possession you were going to go on. So for me, if I'm instructed in something's rent arrears, the first thing I want to know is ground 8 made out? So currently that's at least 2 months of rent or 8 weeks of rent. It's going to be 3 months or 13 months. But so based on now, is the 2 months rent owing? If there is, then my suggestion would be a notice seeking possession under Section 8, relying on grounds 8, 10 and 11. The reason I add the other 2 on is that ground 8's made out if it's at the time of service of the notice, there's at least 2 months, but also when the possession order's made. So if I go to court in a couple of months' time or something, and the tenant's brought the arrears down below 2 months, and we'd only put ground 8, well, there's no ground for possession. Whereas if you've added the other 2 in, the court could still exercise discretion if you ask them to. Like they might still owe a few pounds, or they might have had, a long history of paying the rent late, and that can be ground 11. So that would be the notice, but otherwise, it's trying to speak to the tenants, and if they might have come out of a job, they might have welfare benefit problems. We're certainly going to need to start doing that under the new rules, because we're going to have to say that the arrears aren't because of universal credit problems, for example. But literally, if you're doing everything and no one's responding to you, it's then again, if I was an agent, I'd be saying to my landlord, well, one, do you want us to carry out a property inspection and see if we can do a door knock or something? There might be a welfare concern. How do we know this person's not in a hospital? Could have passed away. They may have left, obviously. But 2 really is, do you want us to serve a notice and seek possession of the property? We can't just carry on letting the arrears accrue. Impacts on the landlord, impacts on you. You're not receiving any commission. So, they would be the things, really.
And then so just on the back of that, then going about that they may have left the property. So another question that's come up is that currently rental arrears on the property. They've been to the property to do welfare checks. The tenant wasn't responding. They've seen that the property is being completely emptied of personal belongings. So what would you do in that case?
So
because obviously they've still got a tenancy in place, right? But from looking at it, we can see that they've left. because all of the stuff's
Yeah.
gone.
And I have that question a lot. It's quite common, and a very much a belt and braces approach. And the reason being is, if my advice is change the locks, and someone does that, and then the landlord ends up getting fined or sued, I'm professionally negligent. And also, I've literally been in a situation where I've given this advice to a landlord which has been ignored, and that is what happened. That in this scenario, I'd served notice on the tenant. The landlord had inspected. Well, that's what they told me anyway. I think they'd looked through the window and seen that it was empty.
Yeah.
And there were joint tenants, and all the stuff I'd paid had gone. They took the property back anyway. A few weeks later, the other joint tenant appeared, and apparently they were in a relationship. They'd split up.
Right.
He'd gone to stay with his parents, something like along those lines. Anyway, and that resulted in an unlawful eviction claim.
Yeah.
And a prosecution. So, but my advice was, well, issue proceedings. That's my advice. Get possession through court. But that it wasn't followed. And then the person was prosecuted and fined and sued.
Right.
So in terms of what does that mean for everybody? Well, it doesn't mean that's always going to happen. And no doubt countless times when people just leave. Happens a lot in student accommodation, for example. They just leave at the end of term and they're never coming back, clearly, because they've gone back home or something. But there's an act called the Protection from Eviction Act. It gives rights to tenants that they can't be unlawfully evicted. The consequence can be criminal and civil. And if someone comes to me for advice in that scenario, I'm going to be saying, well, has the tenant themselves told you that they've left and they're not coming back? Or have they given you the keys back? And if the answer is no on either of them, my advice is going to be serve notice, issue proceedings.
Do it that way.
Because how do we know they're not in hospital? How do we know they're not in prison?
Yeah.
How do we know they haven't had a relationship breakdown and someone's cleared all the stuff out without telling the other one? Could have been a burglar. It could be any number. I don't know. It could be any number of things. But what we would know is that the tenant hasn't said have gone. So if they haven't said have gone, we don't know they've gone.
Yeah.
Even if they seem to be living in a house round the corner or next door, they haven't given up the tenancy. So if you're then prosecuted and if you're sued and the tenant seeks an injunction to get back into the property and or a damages claim and costs, what's your defence going to be? Your defence is going to be, I thought they'd gone. And then you're going to be asked, well, where's that from? But you're going to have to prove that tenancy had ended or they'd given up vacant possession.
So if we had a tenant where the tenant just said, I've left. Sent an email, said I've left. We've tried contacting the tenant, no response whatsoever, completely ignoring us. We've gone to the property, it's empty. At that point, would you do an abandonment notice? Or
well, I think if they've sent you an email or a text,
because they haven't handed keys back.
Well,
so
if there's something evidentially that you can point to, not just word of mouth necessarily, but even then you could make a file note. But if there's an email saying I've left, for me that's good enough. It doesn't matter if they haven't handed the keys back, because how do we know they've handed every key back anyway? But if they're literally saying I've left, ideally we'd want them saying I've left and I'm never coming back, right? But they don't know that, and we may not ask. So each case is different, and you look at specifics on each case. But generally speaking, if someone says I've left, that's good enough for me usually. In terms of an abandonment notice, people ask me about these a lot, and they could be a bit of a red herring because they don't have any legal effect. So an abandonment notice might say, you stick it on the door, then we haven't heard from you for 6 weeks or whatever it is, and we're concerned you've left the property, and if you don't contact us within 24 hours, we're coming to change the locks. Something along those lines. Well, that isn't going to save a landlord or an agent if the council come at you weeks later and say, you've changed the locks on this guy and he's been in hospital, he's been in prison, and we don't know anything about removal of stuff, so we're prosecuting you.
Right.
That isn't going to be a defence. There's no legal effect to it, as I've said. It might be a mitigating factor as to why you've done it, but it doesn't mean it's not an unlawful eviction. At best, it's kind of a scare tactic warning, and you're hoping that it makes them take their head out the sand. So I don't have an issue with them being used, because sometimes they work, or put them through the door or put them on the door. But I wouldn't say that gives you the basis for actually changing the locks. It would be, again, if I was an agent acting for a landlord, I'd probably be saying to the landlord at that point, look, this is the scenario. The legal route is to issue proceedings, because that will protect you. There's a cost and it takes time. If you want to change the locks, that's a matter for you. We don't recommend it because the tenant hasn't said they've actually left. It's on you. It's on you, basically, to do that. But it's never what people want to hear. Obviously, they want to hear it's all okay. And people will, ask me that, and I'll always give them the same advice, that do it this way. Some people don't like it, and that's fine. But I'm not comfortable with saying to someone, it'll all be okay, don't worry, change the locks, and I wouldn't.
Especially if there's risks there, right? There's still getting prosecuted because you've changed the locks.
It's just not worth even if you have a scenario where, and I've been in this scenario where a tenant has said, I've left, or sorry, I'll rephrase that. A tenant and a landlord have agreed to meet at the property because the tenant wants to leave or something like that. And it's not quite clear how they ended up leaving, because there's no more than, we're planning to leave. Doesn't mean they have. And then the landlord changes the locks, and the tenant comes back and says, you've changed my locks. Well, we may have a good defence, right? As a landlord, we may say, well, we agreed, I met you, or you didn't turn up, I changed the locks, whatever it may be. It doesn't mean the tenant can't get legal aid, right, to go off and instruct the solicitor and take you to court. And it doesn't mean that the case won't go on for 6 months, 12 months, 2 years. And at the end of it, you may win, and that's great. But you've spent 2 years in court, or however long, you spent thousands and thousands of pounds. You're never getting that money back off the legally aided tenant. I mean, that's a broad brush approach, saying legally, not all tenants will have legal aid. You may as well have just spent the money on evicting them. Right? It would have taken a few months probably, and you've had peace of mind. And yes, you've spent money,
and you've done it the correct way.
But so I mean, I would always say, if in doubt, take advice. I will certainly speak to anyone who needs. If someone wants to ring me or email me and say, "This is the situation. What do you think?" I will happily tell them what I think, unless there's something concrete saying I've gone. My advice is probably going to be, don't do it. Or you make the decision yourself.
Absolutely. Philip, it's been great having you on. So much value that you've given, so much stuff that we've talked about, which most landlords out there wouldn't know. I know that for a fact.
No problem.
So you've been great on. Listeners, Philip's details will be in the show notes. If you do want to reach out to Philip, his company, his email address, telephone number will be in the show notes. Happy to help you in any way that you can. But Philip, like I said, thank you for coming on.
Thank you for having me.
It's all right. That's no problem at all. And then we'll see you next time.